gentleman from California.
I thank the gentleman. You know, I just pose a question to the chairman. I appreciate you raising separation of powers concerns. I don't think they're implicated here. But I'm curious, Mr. Chairman, do you support a code of ethics for the Supreme Court?
I think the court has always maintained its ethical standards run through the Chief Justice. I think that's what should continue to happen.
And so is this because you have more confidence in 9 people with the power that they have? They don't need a code of ethics, but members of Congress do because they're operating on a higher moral plane or something? I don't understand. Why do we have a code of ethics, but the court doesn't need one? Can you explain that?
If the court wants to impose a code of ethics on themselves, like Congress has done to us, that's fine. But I leave that in the hands of the highest court in the land. I think that's consistent with the Constitution, as Ms. Hageman referenced earlier, and that resides with the Chief Justice of our Supreme
gentleman
Court.
Would the gentleman yield?
In just one moment, I have to yield. But you know, there are few bodies with the kind of really almost absolute power of the court within its domain. And really, Mr. Chairman, you think with all the power the Supreme Court has, we should leave it completely up to them whether they want to feel that they have to abide by any code of ethics. Just going to leave it up to them. And if they want to become secretly beholden to very wealthy people with interests before the court, if they want to do that, well, then we're just content with that. We're content to leave it to them and just hope for the best. Is that where you're coming from, Mr. Chairman?
I gave you my answer.
Would the gentleman yield?
I'm happy to yield.
I just want to point out that, contrary to the chairman, we impose the code of ethics on ourselves. We impose the code of ethics on all federal judges other than the Supreme Court judges. And we can, by the same power, impose the code of ethics on the Supreme Court, though this amendment doesn't have us do it. It delegates that authority to the Judicial Conference. I yield back.
And I thank the gentleman for yielding. I mean, clearly, I struck a nerve here by pointing out the way in which the Senate Republican leader has packed the court, and I understand why that strikes a nerve. But let me tell you something. It may be offensive to Republicans on this committee to consider that court packing. But what is debilitating to the rest of the country is they've lost their reproductive freedom because of that packing. Because without it, millions of Americans would have control over their bodies that don't have it now. So you can say, well, we don't like the connotation that this was packing the court, because there's only one way to pack the court, and that is by expanding it. That's your view. But no, I think for millions of people that just lost their rights, they think there's clearly more than one way to pack the court, and you did it, and you did it. And the only question, I think, for the rest of us is whether we're prepared to do anything about it. Because the alternative is that for the next 30 years, we're going to have a reactionary court with a reactionary agenda, disregarding decades of precedent. That's the reality that millions of Americans are going to face if we do nothing about it. And if we can't even take the baby step here today of imposing a code of ethics, or at least not enlarging the court's power until there is a code of ethics, so we can't even take that step. And Mr. Nadler's exactly right. This step is even one step shy of imposing code of ethics, just saying, let's not expand the court's power until they have some ethical code. And that's even too much. But I guess when they're doing your political work, then no ethical code is necessary. I mean, we've seen that time and time again with the last administration, that as long as the last administration was furthering a reactionary agenda, no ethical code was necessary for the former president, and no ethical code is necessary for the current court. With that, I yield back.
Gentleman yields back. The gentleman. That's right.
I yield back.
Gentleman yield back. The gentlelady from Indiana is recognized.
I'm going to strike the last word. I actually do not take, and agree the notion with gentlemen from California that Supreme Court can take rights, because Supreme Court cannot give us any rights. All rights are provided by our Constitution and the people. And if the people believe that some rights needs to be in the Constitution, we have a process for constitutional amendments. We have this legislative branch that can legislate. But courts shouldn't be given or taken rights. It's interpret the Constitution. And if it is interpreted incorrectly, the courts can reinterpret that. But if we believe that the rights should be given, they should be explicitly stated in the Constitution, and we have a process to do constitutional amendments. If a gentleman doesn't like it, he should work on this process. If American people believe in to have given more rights and protection, they should be constitutional, like we have a Second Amendment rights, which actually under attack. But I also believe, we do not have this high moral ground to decide what is ethical or not. There are some transparency things that courts should recuse themselves. It already exists. There is financial disclosure. We can do it. But each branch should decide what code of ethics needs to be there. And our branch is infringing on other branches' rights and separation of power if we decide what kind of code of ethics they need to have. We follow our code of ethics, they need to decide, but there are some requirements could be. But we have no right to tell other branch what kind of codes they should have. And there is infringement on the separation of power, which is extremely important. So I completely disagree with this notion and debate here. And we have a process. If you disagree what courts does, we can override it, because American people have that ability. And it actually was done on purpose to make sure that we do not misinterpret and change our Constitution, because if we become a country with each government, the Constitution is changed. We create instability, and we'll start reminding third world country where each government comes and start interpreting the laws in a different way. So I think we have a very important institution. I think there is a lot of politics about packing, not packing, but it is very dangerous to go and set the precedent that we are going to start changing the number of justices, we're going to start changing the rules because we don't like. Elections have consequences, and elections have results. But ultimately, when you have justices, which actually originalists, they interpret Constitution how it's written. And a lot of times, even my conservative friends don't agree with that. But I think we do have a lot of good justices there that truly believe in the limited government and the rule of law, and believe their functions is, to interpret Constitution. And sometimes it doesn't land what Republicans like. So I would not say that the court is political. I actually think we have a lot of justices that me as a common sense person and not an attorney, but when I read in the opinion, I actually agree with a lot of that. So I think it's really the right thing to do, for us to respect the other branches, whether we agree or not, and deal with the work we should do as our branch. And I truly believe we also don't do enough work to oversee executive branch, pass budget, pass legislation, and have accountability regardless who's in charge, Republican and Democrat, because I think our branch lost their relevance and has a very low approval rating because we're not doing our job. And the power of a purse is one of the most significant powers that's given to this branch, and we cannot even pass budgets, and we cannot even, hold other ones branch accountable. I think maybe we should concentrate on our job instead of, criticizing some other branch and try to use a political message in which we're unhealthy and puts a lot of necessary pressure on justices there, and really put their lives at risk, because we politicize in Supreme Court, and this is really something that differentiates the republic from pure democracy, which leads a lot of to dictatorship, and we have to keep this republic strong. It's very important, because this is the last stronghold that we have around the world, and maybe we can have more productive debates on real issues, not really doing politics. And I yield back.
The gentlelady yields back. Is there further discussion on the amendment? Seeing none, the question is on the amendment offered by the gentleman from California.
Jim Jordan and Adam Schiff, two powerful representatives, faced off in a heated debate that captured the nation's attention. The issue, the Supreme Court, accusations flew and tensions soared as both sides dug in. This was no ordinary hearing. It was a spectacle of political theatre. It was a battle for the soul of American justice, with each side claiming the moral high ground. At the heart of the debate lay the court's recent decisions, which had sparked widespread controversy. Republicans, led by Jordan, expressed outrage, accusing the court of overstepping its bounds. They saw a pattern of judicial activism that threatened their vision of the Constitution. Democrats, with Schiff at the helm, countered with charges of their own, defending the court's integrity. They accused Republicans of hypocrisy, arguing that their criticisms were politically motivated. The hearing became a microcosm of a deeply divided nation, reflecting the broader ideological battles that define American politics today. Jim Jordan, with characteristic bluntness, launched into a fiery indictment. He didn't mince words as he addressed the crowd, his voice echoing with conviction. He accused Democrats of waging a war on the Supreme Court, a battle that he claimed was both strategic and malicious. Their weapon of choice? Delegitimization. According to Jordan, this tactic was designed to erode the court's credibility and sway public opinion. Jordan argued that Democrats, angered by rulings that contradicted their agenda, sought to undermine the court's authority. He painted a picture of a calculated effort to destabilize the judiciary. He pointed to calls for court expansion as evidence, suggesting that such moves were part of a broader scheme to reshape the court in their favor. Packing the court, he warned, would be a disaster. It would not only disrupt the balance of power, but also set a dangerous precedent. It would erode public trust in the institution, making it difficult for the court to function effectively and maintain its role as an impartial arbiter. Jordan further claimed that Democrats were engaged in a dangerous game. He warned that their actions could have long-lasting repercussions. Their attacks on individual justices, he argued, were beyond the pale. Such personal assaults, he said, were unprecedented and deeply troubling. He accused them of hypocrisy, noting their past defenses of the court when it suited their political goals. This inconsistency, he suggested, revealed their true intentions. The Republican message was clear. The Democrats were playing politics with the highest court in the land. This was not just a political skirmish, but a fundamental threat. This, they warned, threatened the very foundation of American democracy. The integrity of the judicial system, they argued, was at stake. Adam Schiff, in his typically measured tone, offered a starkly different perspective on the current judicial landscape. He stood firm in his belief that the integrity of the court was under threat. He accused Republicans of manufacturing a crisis, suggesting that their actions were a deliberate attempt to undermine the judiciary's independence. The real threat to the court, he argued, came not from Democrats but from Republicans themselves, who had been systematically working to tilt the balance of the judiciary in their favor. Schiff pointed to decades of conservative efforts to reshape the judiciary, highlighting a long-term strategy that had been in play for years. The Federalist Society, he argued, had become a breeding ground for ideologically driven judges who were more interested in pushing a political agenda than upholding the law. Schiff reserved his harshest criticism for Justice Clarence Thomas. Pointing to what he saw as clear ethical violations, he called for an investigation into Thomas's financial dealings, suggesting they might warrant impeachment if found to be improper. The Democratic message was clear. Republicans had already packed the court with their own picks, and any claims of foul play were hypocritical. Their cries of foul play rang hollow as the public began to see through the political maneuvering. The court, Schiff argued, was already facing a legitimacy crisis. But it was a crisis of the Republicans' own making, one that could have lasting repercussions for the nation's highest judicial body. The hearing, though just one event in a long-running battle, underscored the fragility of American democracy. The Supreme Court, once seen as above the political fray, had become a partisan battleground. The implications were profound. A loss of faith in the judiciary, both sides agreed, threatened the very rule of law. Yet despite the shared sense of urgency, no easy solutions emerged. The hearing ended as it began, with accusations unanswered and divisions deepened. The